Good afternoon, everyone. Good afternoon. My name is Neil Joseph. I'm a 2L here at Duke Law, and along with my fellow Hardt Cup coordinators, Ali Sean Ali Bai, Matthew Conrad, and David Davis, I want to welcome you to the championship round of the 2019 Hardt Cup. Two quick reminders. First, please keep your phone silenced at all times. And second, please keep your seats once the arguments have begun. The Hardt Cup is our first year moot court competition, and for many competitors, their introduction to oral advocacy. Putting it together required a tremendous amount of effort and could not have been done without the help of faculty, practitioners, the clerkship office, and the entire Moot Court Board. We want to thank you all for your time, patience, and effort throughout this process. We are honored to welcome our judges today. Judge Jeb Boasberg from the United States District Court for the District of Columbia, Judge Michelle Childs from the United States District Court for the District of South Carolina, and Justice David Nahmias from the Supreme Court of Georgia. Arguing today are Zeke Starr for the petitioner, the Association of New Jersey Rifle and Pistol Clubs, and Alexandra Belzley for the respondent, the Attorney General of New Jersey. Zeke is from Nashville, Tennessee, and graduated from the University of Tennessee at Chattanooga with majors in political science and history. Here at Duke, he is a member of an active investigations team of the Innocence Project, the Mock Trial Board, and coaches the Duke undergraduate mock trial team. This summer, Zeke will work with the Colorado Capital Defender's Office doing death penalty work. Alexandra is from Prospect, Kentucky, and graduated from the University of Chicago in 2015, majoring in English. She spent 3 years before law school as a teaching assistant in the Bronx and as a fundraiser at Steppenwolf Theater in Chicago. At Duke, Zan is on the board of Outlaw and worked on a pro bono project with the Environmental Law Society. She will be working this summer at Rush Legal at Rush University Medical Center in Chicago. The case for this year's Hardt Cup centers around the constitutionality of a New Jersey law regulating gun magazine capacity. The Supreme Court has only once addressed the constitutionality of gun regulations in District of Columbia versus Heller. In Heller, the Supreme Court held that the District of Columbia's total ban on handguns was unconstitutional. The court has not, however, addressed Second Amendment rights outside of the context of a total ban on handguns. The New Jersey statute makes it illegal to possess a magazine capable of holding more than 10 rounds of ammunition. For purposes of the competition, we have assumed a magazine is an arm under the Second Amendment. The petitioner argues that the law unconstitutionally bans an entire class of arms protected by the Second Amendment and impacts the ability of law-abiding citizens to defend themselves in the home. The respondent asserts that the law does not infringe the rights of law-abiding citizens and that it is necessary to reduce the impact of mass shootings. Thus, the question before the court today is whether this statute violates the Second Amendment. With that, we hope you enjoy the competition and good luck to the competitors. Thank you.
The Honorable the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before this court are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning and welcome everyone, and we are ready to proceed.
Madam Chief Justice, may it please the court. Good afternoon. My name is Zeke Starr, attorney for the petitioner, the Association of New Jersey Rifle and Pistol Clubs. With the court's permission, I'd like to reserve 2 minutes for rebuttal.
Thank you.
Today's case is about the constitutional right to choose how we defend our homes. We ask that you find for the petitioner and grant a preliminary injunction for the following 2 reasons. First, this law triggers strict scrutiny because it targets the use of commonly held weapons within the home.
How are you defining commonly held?
Yes, Your Honor. Well, as this court said in D.C. versus Heller, the parameters of the Second Amendment we should be looking at are commonly used weapons at the time. So here there is evidence on the record that large capacity magazines, here magazines that are larger than 10 round capacities, are in common use. Millions of them have been purchased since the mid-90s. In fact, 63% of gun owners actually report having them equipped to their long guns, in addition to them coming factory standard on many semi-automatic handguns and rifles. And second, we ask you to find for the petitioner because this law is too loosely tailored to connect to the government's purpose that they're articulating under any level of heightened scrutiny.
So is the core Second Amendment right at issue here the right to keep a handgun in the house, or is the dissent says the right to keep weapons in the house?
Yes, Your Honor. The core of the Second Amendment does extend beyond handguns.
So in other words, so any weapon that you could defend your home with would be core Second Amendment. Like grenade launchers, that would require strict scrutiny for a ban on grenade launchers.
No, Your Honor. As this court said in D.C. versus Heller, the limiting principle is the weapons that are in common use. So essentially, this court didn't question why handguns were chosen by Americans. It was simply sufficient that Americans had chosen them overwhelmingly as a means of self-defense.
But isn't that a one-way ratchet that every time it sounds like that's the NRA's stump speech, get people to buy more tricked out weapons because the more they buy, the more in common use they'll become, and then the more protected they'll be by the Second Amendment?
Yes, Your Honor. I think in this case, the question is what the area we're looking at for the right in the Second Amendment, and that's to use these weapons within the home. So this court suggested some other factors that we need to look at, specifically whether or not they're used in the home, whether or not they have a reasonable use in self-defense. And both of those factors are present with this law. Because these magazines are commonly held within the home.
Only in the home?
Your Honor,
Core right extends only to your home?
Your Honor, the within the home is a factor we should be looking at in how much it burdens that right. However, there are still rights outside of the home. We're not suggesting that New Jersey could ban totally guns outside of the home, but simply that we should examine more carefully a law that targets or burdens the use of these weapons in the home, because that is, as this court said, where the need for self-defense is most acute.
But it sounds like your evidence is based on how long we've been purchasing. And, back on the question of my colleague about the NRA stump speech, should we be looking at mass shootings? Should we be looking at more predictive behaviors about the outcomes and things of that nature? Or just accept your premise that just because they've been bought this long, then all of these rifles or any other type of weapon is okay?
Yes, Your Honor, I think that would go to the tailoring analysis that we'd be looking at. The threshold question is whether or not a weapon is going to be protected by the Second Amendment. And here we believe that these weapons, as they're commonly held by millions of Americans and used in the home for self-defense, should be protected. Then the question is whether or not the tailoring of the law.
But do you really have evidence of being commonly used in the home for self-defense?
Yes, Your Honor. The record says that these weapons have been used for self-defense. In fact, New Jersey actually—
But don't we have evidence to the contrary that they've been used in mass shootings?
Yes, Your Honor. But as this court noted in D.C. versus Heller, we can't just interest balance here. It's not just the fact that because these weapons have in some cases been used for mass shootings that we should look at them differently. 69 people a day were killed by handguns when this court decided Heller. But that wasn't enough for them to feel that the total ban was unnecessary.
The trial court here made what is denominated as a finding that the record demonstrates that large capacity magazines are not well suited for self-defense.
Yes, Your Honor.
What do we do with that finding?
Yes, Your Honor. Well, first, there is some also additional evidence that they have been used for self-defense. In fact, New Jersey thinks that they're well situated for self-defense. Their previous carry law actually required that no one could take these kind of magazines outside of their homes except for people at a high risk or danger that might need them for self-defense.
So, but there's evidence on both sides of that issue, right? And the trial court made a finding that these are not well suited for self-defense. Do we owe some deference to that finding?
Yes, Your Honor. While there could be some deference there, the fact that they may or may not be well suited isn't the issue. As this court noted in D.C. versus Heller, we should defer to the American people's choice in how they feel best able to defend their homes.
So when you say this large capacity magazine is now in common use, is that 10-round magazine? How about a 30-round magazine? Is that in sufficiently common use to be or right?
Your Honor, the government would have to produce evidence to demonstrate whether or not it was in common use.
But you're saying they would have to, but aren't you shifting the burden? They would have to produce evidence that it's not in common use for it not to be a core Second Amendment right and not get strict scrutiny.
Your Honor, if we had evidence on the record, whether one way or the other, how prevalent those are, I think that would go to the tailoring analysis. Because if we're looking at some kind of, like you mentioned earlier, grenade launchers or something like that.
But why doesn't it go to the level of scrutiny? Because isn't the question of whether a certain weapon is possessing it in the defensive home a core Second Amendment right? That's what dictates the level of scrutiny, doesn't it?
Yes, Your Honor, and here we don't know exactly how many Americans use 30-round magazines, but we do know that millions of them have chosen these 10-round magazines. In fact, they come factory standard on lots of guns. That fact in itself tells us that we are looking at the core right here, in addition to the fact that we're specifically burdening the use of these weapons in the home.
All right, we're talking to you a lot about the level of scrutiny. Tell us, why is this not narrowly tailored?
Yes, Your Honor, for several reasons. First, the law is arbitrary in its scope. There's absolutely no evidence on the record why the number 10 was chosen by the state of New Jersey. There's nothing on the record that shows that anyone in a mass shooting has used a magazine smaller than 15 rounds, and yet the state of New Jersey has chosen 10.
So they'd be fine if it was 15 or 20. You'd agree it would be sufficiently tailored.
Your Honor, I think that would go to the second element here, which is that this law is too broad, because it burdens more legal activity than it does illegal activity.
The 15 rounds would be okay.
Your Honor, respectfully, no. It would depend on what the evidence said. But here, even a 15-round magazine...
So we have some evidence about the number of, the size of magazines used in mass shootings, and 15 or 20. Is that okay? Not okay?
No, Your Honor, because that would again go to the fact that this law is both too over-inclusive, because many Americans choose to use these weapons in their home. Essentially, it burdens many Americans' use of them in self-defense.
What about 100 rounds?
Well, Your Honor, I think 100 rounds would probably there not be a lot of evidence that those are commonly used, and there could be a narrowly tailored purpose there for public safety, for restricting those. That would be the government's job to demonstrate that there's evidence of that connection, and that simply hasn't been shown here with the number 10, let alone the number 100. In addition to that being too burdening many law-abiding Americans, what it does here is essentially it asks Americans to have to make a choice about how they defend their homes, and it restricts the opportunities they have. The record tells us that...
Well, you acknowledge the government can require some choices. They can't have grenade launchers.
Yes, Your Honor.
There has to be at least one limit.
Yes, Your Honor. There are some restrictions that the government can make. For instance, an easy example would be serial numbers on guns that doesn't affect the core function of a weapon. But what happens here is the paramount weapons of self-defense, which is often handguns, those are affected, as well as long guns, by something that restricts the magazine capacity so much. Here, Americans, we know from the record that of the 411 home invasions involving guns over the last 6 years, 84% of the time, shots were fired.
And what percentage were more than 10 shots fired? An incredibly small percentage.
Yes, Your Honor. While that is a small percentage, we shouldn't determine whether or not there's a constitutional right by how often it's invoked. The question...
But are we disguising the real issue here, which is whether or not there should be a legislative fix versus the court deciding these issues, and that you're just trying to keep the guns out of the wrong hands, whether it's somebody who is not licensed, whether they're mentally ill, whether it's a prior felon, things of that nature, as opposed to letting the courts decide the issue?
Yes, Your Honor, and the legislature could have made any of those choices to address this problem. What they've said is they want to reduce the damage that mass shooters can cause. But instead of doing any of the things you mentioned, restricting having a mental health test, restricting the total number of magazines that somebody could buy, restricting how many guns somebody could buy, they chose to categorically ban a type of weapon that's used in self-defense in the home.
But what are you describing as well-regulated militia? Is there any concern about, in this regard, about the police or law enforcement having a more robust militia versus someone in their home?
Yes, Your Honor, I think that also goes both ways for people using self-defense in the home. Criminals are not going to be dissuaded from acquiring black market capacity magazines. And in fact, this gives a tactical advantage to them in those home invasions over law-abiding citizens. In addition, there's a collective action problem here in the sense that American citizens, they might be following the law, but in the state of New Jersey, it's not that hard to go across the border to any neighboring state, acquire these magazines, and come back as a criminal.
But isn't that a problem with all of these arguments that you can never regulate or restrict certain types of guns or ammunition as long as one state sells them? Because the answer is, well, they can always go across the river to X state. And that seems to be a justification for never having regulation. But somebody's got to be the first. So why can't some states start, and then maybe other states will follow?
Yes, Your Honor, while some state may need to be first, the fact that they need to still pass a law that's going to pass constitutional muster. And the issue here is the scope of this is just too broad. It burdens too much activity. For instance, there's actually already a law in New Jersey's books that I mentioned, that handgun restriction for carry permits, that does the job that they're trying to talk about. And there's no evidence that it's not accomplishing that fact. New Jersey doesn't allow most people to carry large capacity magazines outside of the home. So all this is doing is effectively specifically
Is that law constitutional in your view?
Your Honor, the restriction.
Because if you're going to point to that as something that, well, that's just fine and covers this, do you think that law is constitutional?
Your Honor, if based on the evidence, New Jersey does have the ability to make restrictions on the issuing of concealed carry permits and things like that.
Well, but that isn't an issuance on, it bars people from carrying their 10-round magazine with their handgun from their home, let's say, to their vacation home.
Yes, Your Honor.
So how do you get your 10-round, how do you get your magazine to your home?
Yes, Your Honor. If I'm understanding the question, you're talking about the fact that they still have to transport those in public.
Apparently, you need to get your 10-round magazine to your house.
Yes, Your Honor. And obviously, I think that there's an element here where they're allowing people to purchase these guns legally and then take them to their homes for that use. The issue, the distinction here is that there's a carve-out in the New Jersey handgun carry law that allows people to show a need that they have.
That's a very limited carve-out, though, right? Would it even apply to your client?
Your Honor, that's exactly the point. The fact that that carve-out doesn't even exist in that narrow form for the use of them in the home is why this is too broad.
No, but you're pointing to the state can protect its interests by this other law it has about carrying things outside the home. But I'm not sure you would agree that that restriction is valid. So I'm not sure you can point to that as a way the state can protect its interests.
Yes, Your Honor. I see that my time has expired. May I answer the question and conclude?
Yes.
Your Honor, the example of that is simply that there's already a law in the books that New Jersey has towards this end, and they haven't demonstrated that this new law is narrowly tailored enough to affect that government interest of trying to regulate public safety. For the foregoing reasons, I ask that you fine for the petitioner and grant a preliminary injunction.
Thank you.
Thank you.
You may proceed.
Madam Chief Justice, may it please the court. My name is Alexandra Belzley, and I represent the respondent, the Attorney General of New Jersey. Your Honors, this is a case about a state trying to protect its people in the face of an alarming rise of deaths from mass shootings. This court should uphold the law in question for the following two reasons. First, because intermediate scrutiny is the appropriate approach to analyzing this law. And second, because limiting magazine capacity size is substantially related to the government's important interest in saving lives from mass shootings. First, intermediate scrutiny is the appropriate approach because this law does not burden the core right as articulated in Heller of the Second Amendment.
Do you think what Heller said, that the core, at least the core right is handguns in the home, is the limit of Second Amendment protection?
Your Honor, are you referring to the upper limit or the lower limit?
The upper limit.
Your Honor, Heller specifically referred to the ability of people to defend themselves in the home, and we are following the Heller ruling in that we are not restricting people's ability to
Right, but that's like saying the earliest Supreme Court cases on the First Amendment said that political speech is protected, but nobody says that's all that's protected under the First Amendment speech protections. It would be very odd to say that all you can do is have a handgun in the home under the Second Amendment. Historically, under the precedent of the states that have addressed this issue.
That's true, Your Honor. We are not restricting any particular type of gun, and this law is designed to allow people a magazine capacity that in almost every case in the record has been more than sufficient to allow them to defend themselves in the home.
That's a tailoring issue. I mean, your whole brief seems to merge the tailoring issues of what can properly be regulated with the original question, which is, are you regulating something protected by the Second Amendment to start with?
Your Honor, it's true that the arms that we are restricting, the LCMs, do fall under the Second Amendment. However, they do not reach the core of the Second Amendment. In order to determine the level of scrutiny, we have to look at the extent to which the core is being burdened. That's why we have to do this analysis.
That's not really how we do it in other areas of constitutional law. We don't decide, for example, whether we decide whether a type of speech is protected speech, obscenity, fighting words. But once you say it is covered by the amendment, you apply strict scrutiny. The things we don't apply strict scrutiny tend to be things that only address the manner of use.
That's true, Your Honor. I believe you're referring to the Ward decision as cited in the record. However, the Ward decision does indicate that time, place, and manner, content-neutral restrictions on speech do receive intermediate scrutiny. The state of New Jersey is choosing a restriction that is in parallel to that in the sense that it restricts the form of the particular magazine, but does not actually burden anyone's ability to adequately defend themselves.
That's not a time restriction, a place restriction, or a manner restriction. That's the arm itself.
First, Your Honor, of course the matter of analysis will be slightly different for the First Amendment and the Second Amendment because the language of those amendments is different. But furthermore, in some ways this is a manner restriction because we are making a small restriction on the manner in which people can defend themselves in the home. We have not removed any major choices from them in terms of how to go about that.
Are you looking to evolving standards of decency, or do you believe there's a fixed interpretation with respect to the definitions?
To which definitions, Your Honor?
Well, the definition of the right to bear arms and well-regulated militia. Like, do you believe that the constitutional interpretation of that is fixed, or are we evolving? I mean, we heard the previous argument about we're purchasing guns, and so that leads us to believe that we can now use those types of guns just because that's now considered commonly held.
Your Honor, I believe it's important to look at the current circumstances. The mass shootings that we're facing today are unprecedented in history before sometime in the 1990s. To that extent, we do have to put on a certain new lens. Furthermore, according to an NRA study cited in the record—
Does Heller suggest that you can put on a new lens? Or does Heller said that lens was determined by the people who framed our Constitution and ratified our Constitution?
Your Honor, Heller specifically refers to the types of weapons that are overwhelmingly chosen for self-defense in the home. It is possible that that standard could change slightly from time to time. However, the 11 and greater large capacity magazines are not what is frequently being chosen as a method for self-defense in the home.
So can I ask you the same question that I asked your colleague, which is what do you believe is the core Second Amendment right? Is it to regulate guns? I'm sorry, to possess guns in the home or to possess weapons in the home?
Your Honor,
handguns versus weapons.
Your Honor, I believe it regulates the ability to defend oneself in the home with the particular type of weapon that someone chooses, as long as it is permissible under a constitutionally acceptable law. If someone chose something that was less dangerous than a gun, that would be permissible. But by and large, people—
That's because knives aren't protected by the Second Amendment, though, right?
That's not within the scope of the case, Your Honor.
But aren't you conflating the analysis? Don't you have to determine what's the core Second Amendment right to determine the level of scrutiny before you then decide whether you've fit it successfully?
That's true, Your Honor. In order to do that, we have to determine if people are actually being burdened from their ability to defend themselves, and the statistics in the record show that they are not. In fact, to answer your previous question, the NRA study cited in the record demonstrates that in only 2 of 736 home invasion cases were more than 10 shots fired. And there's no evidence to demonstrate that more than 10 shots even needed to be fired, merely that they were.
Why do police officers want to have more than 10 in their magazines?
Yes, Your Honor, because they're
worried about not just the one incident. There may be one incident out of 1,000, but that one incident is the one they care about, right?
Your Honor, the reason that New Jersey has incorporated a carve-out for military members and for police officers is because their line of duty frequently asks them to defend others outside their own homes, others in much larger amounts than the type of self-defense that is protected under the core as articulated in Heller.
So I can't defend my home against potentially 4 home invaders I can only defend my home against one home invader, knowing that I'll have to reload my weapon.
Your Honor, if someone has that concern, they have the opportunity to purchase as many magazines as they would like, in addition to as many arms as they would like.
But they have to reload or get other arms. The very reasons, and this may go more to tailoring, the very reasons you lay out for why it's important for your law to try to stop mass shootings apply to people trying to defend themselves as well, right?
Your Honor, the mass shootings are the specific issue that we're concerned with because the rise in them recently has been unprecedented, and the legislature of New Jersey is concerned about.
How many mass shootings have there been in New Jersey?
There have been none, Your Honor. That's why we're attempting to pass this law, is because we do not want to become the next state with a tragic headline in the news.
How many homeowners have defended themselves in New Jersey?
I apologize.
How many homeowners have defended themselves using weapons in New Jersey?
That specific statistic is not in the record, Your Honor.
But will you admit that it's more than zero?
That's true, Your Honor, and that's why we continue to allow the opportunity for people to choose a wide variety of weapons and to have as many weapons as they want to possess, as many magazines as they want to possess. We are choosing a less restrictive means of accomplishing our goal in order to make sure that people can still feel safe in their home while also protecting people when they leave their home and potentially become the next person at risk of being a victim in a mass shooting.
So you would suggest that we don't wait on the statistics, so to speak, that even in other areas of law, whether it be employment discrimination, gender stereotyping, things of that nature, if you know that a particular circumstances arises, then we kind of predict out?
Your Honor, I have two things I would like to say in response. First, the unique nature of mass shootings means that we cannot do any type of controlled study to determine what would happen under a number of different circumstances. By the time we have accumulated more evidence, dozens of people have died. We have to look to what has happened in other states in order
to figure out, though, why exactly what you're saying doesn't apply to homeowners and their self-defense. You say, well, we don't know exactly how many times, and we want to prevent even one mass shooting. Don't we also want to allow homeowners to prevent the one murder of themselves and their families?
Your Honor, the record demonstrates that greater than 10 capacity LCMs have a much greater risk of being used in a mass shooting versus not being able to protect themselves in the home. I've cited the 2 out of 736 cases of more than 10 shots being fired.
How'd you get to 10 for mass shootings?
Yes, Your Honor.
The statistics seem to show it's a much higher threshold in actual mass shooting cases.
Your Honor, I would disagree that it's much higher. It is slightly higher. Again, intermediate scrutiny does not require a perfect fit, merely a reasonable one. In one case, the Virginia Tech mass shooting, 32 people died and 23 were injured. This was accomplished with one 15-capacity LCM.
Do you think a 5-round LCM limit would pass intermediate scrutiny?
Your Honor, that would be a much more difficult case. We have chosen 10 because it is well above the average number of shots that are fired in a situation in a home invasion where shots are fired, which according to the record is around 2.2 shots. It is important to us that we restrict people's ability to purchase large capacity magazines only to the extent that is necessary to secure our people in the face of mass shootings, not as tightly as we possibly could. Furthermore, this is the best option available to our legislature because recent mass shootings have shown that in some cases, a pause in which a gunman is reloading can save lives. There are 4 cases cited.
But isn't there information in the record that it only takes 2 to 4 seconds to reload?
Your Honor, the record indicates that that does depend on the skill level of the shooter. For an inexperienced shooter, it may take up to 10 seconds. Furthermore, even those 2 to 4 seconds have saved lives in the past. In the case of Gabrielle Giffords, in the case of the 1993 Long Island Railroad shooting, in which passerbys were able to stop the person wielding a pistol from shooting more people.
I'm still trying to figure out why that argument. So you say for an unskilled person it may take 10 seconds to reload, but then you say homeowners can feel safe because they can have multiple magazines even though it will take them 10 seconds to reload while their home is being invaded and their children are being threatened.
They can also have multiple arms available to them, Your Honor. It is much more difficult for somebody who is going out into public to subtly carry multiple arms. In fact, none of the mass shootings on the record used more than 3 arms. However, if people are deeply concerned, we give them the opportunity to carry multiple arms in their homes. Furthermore, the record indicates that they simply are not, on any statistically significant basis, firing more than 10 shots in defense of their homes. However, every one of the 9 mass shootings cited in the Violence Policy Center study on the record indicates that more than 10 shots were fired. However, as I've stated, the Virginia Tech massacre only used 15. One of the secondary guns in the Orlando massacre only used 17. Therefore, we are aiming to get within the correct range to protect our people in the future by choosing 10 as the LCM amount.
If you do not succeed in convincing us that intermediate scrutiny applies, do you think your law survives strict scrutiny?
Yes, Your Honor. The record does not have in contention that our interest is a compelling one. We have a compelling interest in saving lives in mass shootings. So then we move to the second step. Is this the narrowest possible way to tailor our law to our interests? And it is, Your Honors. We do not have other available options in our legislature that will come closer to accomplishing our goal. It is critical for us that people still be able to enjoy their hobbies, so restricting the number of arms that they have or the number of magazines that they can own in one time is not a possible approach because we would effectively illegalize hunting trips if we were to do that.
Should we be focused just on this LCM, or should we go ahead and list out a cadre of various types of weapons?
Your Honor, are you referring to should we list out a variety of weapons to ban?
Yes.
No, Your Honor, because under intermediate scrutiny, it's important to have a substantial fit, and if Your Honors were to choose strict scrutiny, it would be even more critical to have the least possible restrictive law. We are trying to burden people as little as possible while also making a concerted effort to save their lives in the event that a mass shooter attempts to murder dozens of people in New Jersey next week. Furthermore, we don't have better options available to us because the 2 common factors that we've seen from the evidence that involve lives lost or lives saved in mass shootings are first, that all of these are greater than 10 capacity, and second, that there are cases in which people's lives are saved.
How many you say these are all greater than 10. Are these all the mass shootings that have happened in the United States? And your cases go back, I think, about 25 years.
Your Honor, they're the ones that are available on the record, so those are the cases to which our legislature has the knowledge that we can use as evidence.
But we know there have been hundreds of mass shootings.
If anything, Your Honor, that only heightens the need to protect our people because it only demonstrates that these mass shootings are becoming more of a problem.
Or it tells us that the government, which has the burden of producing a record to justify its constitutional restriction, has not included anything but the cases that help them.
Your Honor, I see that my time has expired. May I finish?
Yes.
Yes. Your Honor, we still have many cases included in which the magazine capacity was much greater, and yet it's important to us to include a range in the evidence to demonstrate the severity of the situation to this court and to explain why we have reached a law that has a substantial fit to our important interest in saving lives. For the above reasons, Your Honor, I ask you to uphold this law and uphold the Third Circuit decision today. Thank you.
Thank you.
May it please the court. A statistically insignificant number of Americans burn flags to protest this government, but we still protect their right to do so and don't tell them they have to pick another option. A statistically insignificant number of Americans may have had to fire more than 10 shots, but that doesn't affect the right that is protected. As this court stated in Heller, the Second Amendment is not to be treated as a second-class right among the core constitutional rights, just because a state legislature sees some policy need. Just because a policy may be convenient does not make it constitutional. This law indiscriminately burdens law-abiding citizens and mass shooters by restricting the way that Americans choose to protect their homes. The respondent said there was no other correlation that they could manage here, but all the mass shooters on the record had significant mental health issues. But New Jersey did not choose to screen for mental health in issuing guns. They also all had many magazines, and New Jersey did not cap the number of magazines that they could use.
It isn't the point that someone, whether you have mental health problems or not, you're going to do a whole lot more damage with 60-round magazine than you are with a single-shot weapon, whether you have mental health problems or not, right?
Yes, Your Honor, and that logic would come down to meaning that New Jersey could ban any number of shots above the average fired. But there's no limiting principle to that. As soon as the statistics change, they can suddenly change the number all the way down to 1 shot.
Well, what's the problem? So why wouldn't a 5-round limit survive intermediate scrutiny?
Yes, Your Honor, under an intermediate scrutiny, again, that number is arbitrary. They're just naming a number above the average and saying that that has a significant connection.
You admit there is a limit that they could regulate even under strict scrutiny, say 100.
Yes, Your Honor, there is a certain point where it could be narrowly tailored to.
Where is that point?
Your Honor, that would be for the government to demonstrate evidence to show what that point is. Your Honor, I see that my time has expired. May I conclude?
Yes.
The choice that Americans make to defend their homes is a central part of the right in the Second Amendment. New Jersey is effectively taking a significant part of that choice away by saying, regardless of where you live, your job, your personal circumstances, or capabilities, you cannot choose to use a weapon that millions of Americans have come to rely on. For the foregoing reasons, we ask that you find for the petitioner and grant injunctive relief. Thank you.
Thank you.
All right.
With you and Judge, such a wonderful competition. The students, and I'm sure the rest of you who have participated in here, are obviously very well prepared. You've done an outstanding job. You really know your record well, and we'll give you some personal feedback. But I feel like this is the voice, and that I have to judge this particular competition. And so as we come together, we are awarding the Hardt Cup to Zeke Starr. And then I'll just start with the judges in terms of just any great feedback that they'd like to give.
Yeah, so this was tough. I mean, what's sort of fun, we were just back there saying how good we thought both of you were, partly because we view the case a little bit differently. I mean, one of us said, boy, that competitor was so good because that competitor did such a hard case. And the other reaction was, what are you talking about? That person's case was easy. The other person had a hard case. And so the answer is that you both got hit very hard. I mean, you really didn't have more than sort of 15, 20, 30 seconds at any point during your delivery, and yet you hung with it so well. I mean, are you so articulate, so clear, so direct to the question? And there were some questions that sort of came out of left field, they were hard to interpret exactly what the judge was getting at immediately, and you did a great job of respectfully nailing that down. I thought you particularly did a really good job on that, which is hard because you don't want to start answering something that isn't really the question, but at the same time, you don't want to insult the judge and say, what are you talking about? Or that's not in the record, or that's not what you're talking about. So I thought that was really great about how you figured out exactly what the question was and then moved on. And then I thought that your rebuttal was really terrific, very distilled. I really like that. Clear, hit your main points. I'm sure you've probably been told that the way you're supposed to end is say, for the foregoing reasons, for the above reasons. Get rid of that. I mean, that's sort of, you both did it. That's sort of the weakest way you can end. I mean, figure out a pithy, hard, because New Jersey has to protect its citizens, we ask you to uphold this law, or something like, I think is much stronger than the foregoing. But again, really, really impressive. The fact that you guys are 1Ls is amazing. And the other thing I would say is, congrats to all of you guys. Wonderful to have all of these folks come out and see. I mean, you could be out in the sun, you could be out watching the UVA highlights, but you're here. I've seen a few people with those shirts around. But you guys are all here supporting your classmates, and that's really impressive to see. So kudos to all of you.
I would say you both had extremely wonderful presence. I mean, you were very articulate, you were very comfortable, very cool-headed. You really know your record well, and that's so important because you were dwindling down into statistics that were, all through the briefs, and just being able to extrapolate some of the issues that were here as well. I really felt like your openings were extremely strong, and to me that's powerful. It gets the ear going right away. And one of the things I always tell lawyers too is, of course, you don't want to read your briefs to the court because we would have been very well prepared through our clerks and ourselves as well, and that you really have to get to high-level issues. You want us to figure out how are we deciding this, and it's more than about this case. We're kind of looking forward in terms of any particular decision and how it's going to affect something later. So I thought you all did a great job about the higher policy arguments, if you will, as well. And then I would only say one little critique about you. One time I asked you a question and you said, yes, sir. I just want you to know there are some women on the bench.
I thought you were both great, and our decision was a razor one way or the other. And every time I go to one of these, I say the best arguments I ever see are at the U.S. Supreme Court and good law school moot courts. Even the very good lawyers we have in front of us are usually not so thoroughly, deeply ingrained in the record and have practiced. And you both had the greatest art of appellate lawyers and the hardest when you have a hot bench of you didn't fight the questions, you answer them succinctly, and then we're very good at moving on to what you wanted to say. Here's your answer, and now I'm going to talk about what I want to talk about, and in being able to bounce back and forth from question here, question over there, question in the middle, and that's an incredibly hard skill. You're trained so much to write something coherent, start to finish, argue if you debated, start to finish, and you don't get to do that in appellate arguments when you have an active bench. You have to answer this question, answer this one out of left field, and I think Judge Boasberg said, answer this question that is really not a good question at all, but that's what judges are going to ask you, and this is your chance to tell them that's really a left field question that doesn't have to do with what you've got to decide, and you guys were really good at that. Mm-hmm. And also very good, as Judge Childs was saying, judges on appellate courts are worried about your case, but they're also very worried about all the future cases. So you got all these hypotheticals, and what about this number, and what about that number in this arm? And again, you didn't fight those and say the worst answer to those, which I hear a lot, is, well, that's not this case. The right answer is, well, we don't have to decide that. The government would have to prove it. You know, we're trying to do only what we have to here. And so really high quality. And again, you know, to step back and think that you've only had less than a year of law school, you and a lot of your colleagues who made it along in this process will be very good if you want to be appellate advocates.
And I'll just open it up, if that's okay, just for any general questions by the entire audience. Several rounds.
But don't go be appellate advocates, be trial lawyers.
Yeah.
Exactly, and it's a different skill as well. You generally have people who are very familiar with the appellate advocacy, and then you have the trial lawyers, but sometimes they merge, but often the skill set is just so different that you don't.
But the advice I'd give, not that anybody asked me, is I remember when I was on my law school's Moot Court Board, and we told people, it's like an obstacle course, and the judges are going to try to distract you and deflect you and throw up some obstacles, and you just got to keep on your path and make your argument. And that's really terrible advice that I gave legions of people. You're younger than me, I don't have forgotten. You're there to answer the judge's question, not to make your argument. I'm asking questions because I want to know the answer. I want to know what your answer is. And if you go off and just tell me something because it's on your argument, or you try to give me as short shrift as you can to get back to your argument, then you're not doing yourself a service. Help me out with my question. And I thought you guys did a good job. I think that's sort of general advice.
And I would say, particularly on the trial level, we don't have to give you argument. And so when we've given you argument, then there's something that we want answered. And usually I'm walking in kind of having my mind made up about where I'm going with it. So the questions I'm asking you are really to decide. And so many times I've had lawyers say, well, I was going to get to that. No, get to it now, because that's what I'm asking. And then every once in a while, if it's a huge case, I might even send out a text order ahead of the hearing to say these are the questions that I would like answered, so that you just incorporate that into your arguments right away, and then eventually you can get back to your presentation. But please don't underestimate what the judge wants to know.
Something that comes up in judging often is your presence, your eloquence, sort of these softer things that are harder to build up with like concrete steps. So what suggestions do you all have for how you develop sort of your judicial presence and sort of these softer skills about how to come up here and appear the right way, how to speak the right way?
One thing I'd say is, you know, and it may not be fair, but you just want to look like a normal lawyer arguing a case. So however you may dress and act and do stuff outside of court, if you do something like that, especially in an appellate argument. Now, jury trials are different because you may want the jury. My wife used to only cross-examine criminal defendants wearing a red suit because that was a way to get the jury watching her and not the witness. But, you know, in an appellate argument, you know, if you're flamboyant, that's usually kind of a turnoff. I think the best way of approaching it is, you know, we are all reasonable people. Let us come and reason our way to the right answer. Of course, I'm going to have you reason it in the way toward my client, but that's the best back and forth approach. We're all reasonable, you know, not loud voices, not interrupting. I mean, be as reasonable as if you were having a reasonable discussion, and that, in my experience, is much more effective than almost any more flamboyant style for appellate arguments. Again, trial lawyer skills are a whole different world than.
But I would just say, don't exude arrogance either. And I say that, you know, just quite intimately and affectionately, and the reason I say that is because we're generalists. We have a broad gamut of law that we have to know and we have to come up to speed on. We recognize that you all are specialists, but you don't have to exude arrogance to us. I remember one time I had someone who is now on the Fourth Circuit, and he was in a trial with me. What were we trying? Oh, someone who did a murder for hire against their wife. They had already been in jail for 50 years for trying to kill the wife and the the father-in-law, and then in jail went on the dark web to get a bomb to try to detonate against her. We can't make these stories up. Well, anyway, so when we're getting to the jury charge, he was saying, Your Honor, that's the wrong jury charge because we don't have a felon who testified. And then I looked over at the defendant because on the rare occasion he did. He goes, you know. And so don't act like you're the smartest person in the room all the time on a particular issue. Just lightly, and I think you all did very well at that. You knew your cases, and then you answered it very comfortably, but you never exuded any type of arrogance in how you did it.
Right. Think conversation, not oration.
Conversation with like your uncle who knows something about what you're talking about, but not everything, because I mean, the U.S. Supreme Court is a little different, but almost every other court that hears oral arguments, district courts or appellate courts, I mean, my court's gonna have 12 arguments in 2 days next week, and we will not be, you know, in the weeds on everyone, and they'll be on 12 different topics. You'll know your case backward and forward, and so, you know, you'll get crazy questions or questions that confuse this case and another case. You guys were really good at, you know, oh no, the record in this case, and point us to the record, point us to the case. Don't resist that as, you know, why are you asking that? Give the answer that helps the judge, because the judge asked the question because they had the question. Give the judge the help with the answer. And again, I mean, compared to the advocates I see day in and day out, you know, your skills at not resisting and at answering the questions that were asked were extraordinary.
Okay, anything else? Well, thank you for the opportunity.